have to mention one item, my lord, that may come up on 3rd May, my lord. Admission matter, my lord, 2020 matter, my lord, regarding regulation of government.
So why 3rd May?
Any date, my lord, I have not seen next week, my lord. Next week, there is no other day, my lord. Monday is
Next
holiday.
week will not be possible.
Then
Any day week commencing from 8th.
Then it may be on 12, my lord.
May I please, your lordship? My lord, a contempt case, my lord, I may be permitted to withdraw, my lord, be listed on Tuesday, my lord.
Maybe. So I beg to mention item number 32 and 33.
Yes.
I made a password for the day, my lord, and there is a status quo order, my lord.
You have informed the other side.
Government, my
On the prayer of learned counsel for the petitioner made with the consent of the other side, this matter stands adjourned for 2 weeks. Same order in item 33 also. The same order. These matters.
But there is a status quo order, my lord, till returnable date.
Interim order passed earlier to continue
Of
till the next date.
May please, Your Lord, I beg to mention item number 34, orders, contempt matter. Lordship, I pray for 3 week adjournment. Last one, I could not meet him for some correspondence is going on. But latest information.
Mr. M. Talukdar, learned counsel for the petitioner, seeks 3 weeks time to obtain updated instruction from his client in this case. Full stop. Since the prayer is not opposed, same stands allowed. Let the matter be listed accordingly. Yes.
Me, please, your lordship, I beg to mention this matter, your lordship. I'm challenging a termination order. The pleadings are complete. The matter will be listed for admission, your lordship, on 8th, if your lordship allows.
8th already, up to 12th, it is already full. You can choose a date after that.
14, your lordship.
May I please? So I am paying for listing of a matter, my lord.
14th is a Sunday, but we may not be coming to court. I don't know about it.
15, your lordship.
For listing of a matter, my lord, in the hearing column, my lord, pleadings has been completed, my lord, 2020 matter, my lord. The petitioner dismissed from service, my lord. Any date, my lord.
Give it 23rd May.
May I please, your lordship. Lordship, I beg to mention item number 35, lordship. Lordship, the here order has been complied, lordship. I may be
Mr.
allowed
Talukdar, learned counsel for the petitioner submits that order of this court has been complied with, and therefore this contempt case be closed. In view of the submission made by Mr. Talukdar, this contempt case stands closed.
May it please the lordship, this matter, my lord, writ petition, my lord, this matter may be listed on my lord Tuesday, my lord, because matter is urgent, because my lord, on 6th of May, my lord, the respondent authority will get appointment, my lord, other 9 incumbent, my lord. So this is urgent, my lord.
3rd May.
3rd May, my
For
lord.
motion.
No, my lord.
Then?
For orders, my lord. Because, my lord, I have challenged for promotion, my lord, from grade 4 to grade 3, my lord. And my lord,
You want an interim order.
yes, my lord.
You'll get it listed, but no order without a IA in a pending matter.
Yes, my lord.
3rd May.
Yes.
Well, item number 41, it is infractions, my lord.
Item,
41, my lord. Contempt.
why infrastructure order?
Order has been complied, my lord.
Acha. Mr. Sohantala, counsel, Mr. Mohantalal, counsel for the petitioner submits that.
But rejected our prayer, but I will.
You are not appearing in this case.
My lord, on behalf of my lord, users, I can.
Mr. U.J. Saigal, counsel for the petitioner submits that the order of this court has already been complied with, and therefore this contempt case be closed. Prayer allowed, this contempt case stands closed.
That is rejected, that is why we come with a fresh writ petition.
May I please, your lordship? Lordship, I beg to mention
Then
item.
The order of, in compliance with the order of this court, the prayer of the petitioner has been rejected, and therefore a fresh cause of action has arisen in this matter. In view of the above, this contempt case stands closed by granting liberty to the petitioner to assail the order if so advised.
May I please, your lordship? Lordship, I beg to mention item 36. Lordship, this matter may be, I want to withdraw this matter, it will become infructuous.
Why want to withdraw? We'll close it. Why order has been complied with?
No, lordship, the main petition is already dismissed, lordship.
All right, you write, Mr. I. Ahmed, learned counsel for the petitioner submits that the main writ petition has been dismissed by this court, and therefore this contempt case has become infructuous. In view of the above, this contempt case stands closed.
I beg to mention for listing, my lord, on 15th of May, writ petition, my lord.
What is the matter about?
My lord, one is, my lord, appointment on compensatory ground, another is one disciplinary proceeding, my lord. I have challenged the discipline.
You want both on 15th.
Yes, my lord.
Why? Why? 15th is not possible. 23rd,
Obliged, my lord.
22nd, 22nd.
Obliged.
May please your lordship. Lordship, I beg to mention item number 44 from today's list, my lord.
Yes.
My lord, the respondent authorities have already complied with the order, my lord.
Item 44.
Item
Mr.
44.
S. Upadhyay, Nayak Counsel for the petitioner submits that the order of this court has been complied with and therefore this contempt case be closed. In view of the submission made by Mr. Upadhyay, this contempt case stands closed.
Highly relaxed, my lord.
May it please your lordship. Lordship, with the consent of the other side, I beg to mention item number 14 of today's daily list.
Hmm.
The engaged counsel B Pathak due to some personal difficulties is not available.
Item number
14,
40.
so 1-4,
Yes, what do you want?
lordship adjournment.
Acha. A prayer for adjournment has been made in this case on behalf of the petitioner on the ground that the arguing counsel is unavailable. Since the prayer is not obtained, same stands allowed. This matter stands adjourned for 3 weeks.
Duly approved.
May I please, I beg to mention for listing of an admission matter, lordship, 22nd of May.
22nd.
Obliged.
May I please your lordship, I beg to mention for listing of a matter lordship pertains to Gaubura, appointment of Gaubura lordship.
Admission,
Yes,
22nd.
22nd, May lordship. Obliged.
Daily list for motion item 1.
Yes,
May to the lordship. Then this matter pertains to recruitment in the Central Armed Forces Police, Armed Forces.
so these are covered cases,
Yes, lordship. Lordship, at this stage, lordship.
covered case.
Covered
Where
case.
where is the order, last order?
Yes, lordship. Lordship,
All writ petitioners.
Uh,
All
there-
writ petitioners are
there is
entitled.
only one in item number 1 and in item number 2, all are represented, all are covered. lordship.
Acha. Same order is there, just CBC is SS Roy, or Sharma. In item 1, only one petitioner, and in item
2,
2. there are-
11 representatives.
So all the writ petitioners are entitled,
Yes, lordship.
disposed of 1 and 2.
Okay.
Similar order, same order. You have seen this order, it is otherwise correct, the
Yes,
earlier
Lord.
order?
Yes, yes.
Item 3.
Lordship. Yes, the petitioner is the daughter-in-law of the former Gaubura.
Hmm.
He is agreed by the publication of the notification dated 11/23, page 33, serial number 5. Where restaurant number 4, football partner was selected. For the village Jumur Magar.
According to you, the petitioner should have been selected.
Because as part of the condition of the algorithm number 6, page 15.
What is it? Let us see.
Preference shall be given to the family members of Gao Pradhan and views of the modular shall be taken into consideration. These are not considered.
We'll issue notice only at this stage, nothing more. This preference doesn't mean guarantee of anything.
Preference because all the villagers have also given that she should be appointed as a Gao Pradhan.
No, but
there's a
I don't
recess
know
of
how these clauses are being, then why are you holding a selection process?
Lordship, preference, that means if 2 persons come equally, then the preference will be given,
I mean,
lordship.
that's right.
That's not for,
That's why it's given.
not the son or daughter of a.
No, may not be. If 4 and petitioner are equal in standing
Then preference.
and one is former member of the family of the Gaubura, then preference. is-
I have the request, all the requested qualification as per the.
No, that is not the ground. Because you have come, we'll issue notice and dismiss it on the next day after they file their objection. Your understanding of the advertisement clause is,
Also in the executive instruction also there is.
Mr. Gogoi, your place is that since it says preference, so only those family members should be appointed, nobody else, if there is one. That is the argument.
Yes, yes.
That is wrong. But I don't want to dictate the judgment today. You will feel aggrieved. You think about it, come on the next case. Heard Mr. S.R. Gogoi, learned counsel to the petitioner, alleging that the selection process for appointment of Gau Pradhan in lot number 1, Jumurmur and Magar of Kahitoli Moja under Kampur Revenue Circle in the district of Naga has been carried out without complying with the clause number 6 of the advertisement notice, which mandates that preference shall be given to the family members of Gau Pradhan and views of the Mojadar shall be taken into consideration. Full stop. The petitioner claims to be member of a family member of a former Gau Pradhan. Full stop. Responding to the above, Mr. S.S. Roy, learned government advocate Assam, submits that the question of preference will come when two candidates secure equal position on merit, and therefore the writ petition is without any substance. However, the learned government advocate seeks 4 weeks time to obtain instruction and place the same before this court. In view of the above, NOI 4 weeks. Since Mr. S. Dattal, understanding council revenue and disaster management department Assam has appeared and accepted notice on behalf of respondent number 1 and Mr. S.S. Roy for respondent number
2 and 3.
The no formal notice is required to be sent in said respondents extra copy of the information be furnished to the department council. A petitioner takes steps for service of notice upon respondent number 4 by registered post with AD. Hard on the prayer of interim relief, it is made clear that appointment, if any, made during dependency of the writ petition shall be subject to further orders that will pass through.
May I please, Lordship? In this case, my lord, a selection of respondent number 4, my lord, on the basis of recommendation of the local MLA and application of the local MLA recommended by the chief minister, my lord. Page 31 on statement. Page 32 vernacular, my lord. Page 10. Page 32 vernacular. Ramakanto Devi, my lord. The list is page 33.
There are similar matters already. Morigaon district. Where is the order first? You have a copy?
Division 2152. 2023.
Not Mr. A. Mohammed Lamek, counsel for the petitioner. The matter pertains to selection of candidate for appointment in the post of Gau Pradhan in different villages, including Behuguri village. First up, the petitioners submit that the selection of candidates in this case has been made on the basis of recommendations coming from the political executive, and therefore, and not in accordance with the terms and conditions laid down in the advertisement notice. First up, it has been pointed out that similar matters are pending disposal before this court, wherein allegations of political interference in the process of appointment of Gau Pradhan has been alleged. First up, Mr. S. Dattal, understanding council, revenue and disaster management department Assam, and Mr. S. Roy, and government advocate Assam have both paid for some time to obtain instruction in the matter. NOM 4 weeks. Since Mr. Datta has accepted notice for respondent number 1 and Mr. Roy for respondent numbers 2 and 3, no formal notice is required to be sent for the same respondent. Extra copy of the writ petition be furnished to the learning department council. Petitioner takes steps for service and notice upon respondent number 4 by registered post with AD. Registered to list this case again along with WPC number 2152 of 2023. Heard on the prayer of interim relief. Considering the facts and circumstances of the case, it is hereby provided that no order of appointment shall be issued in favor of respondent number 4 till the returnable date.
Earlier case, record was called for, Lordship.
Huh?
In earlier case, record was called for.
Here also you produce the records.
Which is same.
The records of the selection process be produced in the next day, then list along with so and so. Actually,
Next date is 29/5.
then issue notice returnable on 29/5.
5, Lordship, yes. Okay.
No, please.
Item 5.
My lord, this is a case for compassionate appointment. Petitioner's case was considered earlier by the SLC and was rejected on the plea that there is no vacancy. And of the.
So now there is vacancy.
My lord,
Now there is vacancy.
now there is vacancy. That is
How
my.
can it be done?
That.
These
that's
petitions are
your
being
law.
filed. It
That-
will be a never ending business. Mr. Chale, I have seen people saying 96 father died. There, at that time, either he was minor or there was no vacancy. Now they have come for compassionate appointment of cause
No,
arising in
In
96.
this case, he is already.
And the scheme is only to give immediate relief to the victims.
That is true, my lord.
How
that-
these petitions are to be entertained? These are coming in big numbers.
Yes.
The government is just asking for time to obtain instruction. Otherwise, we'll bunch all these things. How can this be done? You please address the court on that. How can the vacancy arising today be used to give compassionate appointment of a candidate who had applied in 2014?
14. That's.
How it can be done?
Petitioner
Timing
has
has-
some.
Huh?
to
All right,
this.
notice,
It
let
is-
this be pending. Heard Mr. D.C. Chale and senior counsel appearing for the petitioner. And the issue involved in this read petition pertains to prayer made by the petitioner for appointment on compassionate ground. Mr. H. Chakraborty, learned and Assam Police for some time to obtain instruction on it. And I am 6 weeks since Mr. Chakraborty has appeared and accepted notice for respondent numbers 1, 4, and 5. And who is the standing counsel? You are appearing for all.
No, Lordship, I am appearing for 4, Lordship.
And who is the
Respond now.
standing counsel, secondary education?
Education.
And Mr. Swanso has appeared and accepted notice for respondent
Education
number 2 and 3. As such, service notice is deemed to be complete in this case. Extra copy
Higher
of the
education.
expedition be
Secondary.
furnished to the learned departmental council so as to enable them to obtain instruction. Let this matter be listed again by showing the name of G. Assam as well as SC, Secondary Education Department, Assam, in the cause list.
Lordship, I am appearing 1 and 4, Lordship. 1 and 4.
That's right.
1 and 4.
1 and 4.
Item 6.
Lordship, I have challenged the notification because Lordship, the order of Lordship, the imposing penalty was withholding of 2 increments. They want to withhold the promotion as per notification that was produced on last occasion, contrary to the rule. That is why I have challenged the notification at Lordship page 135.
Page,
135.
we'll issue notice.
I have been imposed minor penalty of withholding of 2 increments. They are withholding the promotion on the basis of notification, late notification. 135. Lordship.
Yes, who is appearing in this case? Mr. Sharma, you are appearing?
For respondent number 1, Lordship.
In this read petition, the notification dated 1987, issued by the Under Secretary to the Government of Assam, personnel bracket B bracket close department is under challenge. Not Under Secretary, Secretary to the Government of Assam, personnel B department. B department Assam, wherein it has been laid down that penalty
Right.
of
Easy.
withholding of increments, withholding of increment within course, or withholding of promotion again within course, withholding of promotion within course. Promotion can be given to the candidate only after the expiry of the penalty. So, penalty has been laid down. heard Mr. S. K. Goswami, like counsel for the petitioner, who submits that this matter is required to be taken up along with the connected read petition being WBC
2125.
number. WBC number
2125 of 2023.
2125 of 2023. Mr.
2124, no?
H. Sharma, learned additional senior government advocate Assam prays for some time to obtain instruction in the matter. And I'm notice of motion returnable on when is the other matter fixed?
Along with that petition.
Returnable in 4 weeks. Since Mr. Sharma has appeared and accepted notice on behalf of respond numbers.
I am for respond number 1, Lordship.
Respond number 1, Mr. R.M. Das, Learned SC Water Resources Department for respond number 2. And 2, 3, and 4, and Mr. S.K. Medhi, Learned CVC for respond number 5. Service of notice is deemed to be completed. Extra copy will be requisitioned with to the Learned Department Council so as to enable them to obtain instruction. These matter will be listed again along with WPC number with that number.
Obliges. Not so good.
Yes.
But petitioner applied for the post of attendant grass cutter and size measure. And she was not preference on the ground of age measure. On 1/4/2023 ballot, he was rejected on the ground of remarks a candidate age over. But advertisement ballot page 34, it is revealed that if the age was counted on 1/7/22, her age would be 42 years, 6 months. And relaxation of upper age mallet of she belongs to mallet OBC. That is mallet she will get the 3 years benefit. And on the benefit mallet her another 6 month mallet she will be entitled to get that.
We issue notice at this stage heard Mr. B. Islam Naik counsel for the petitioner. The read petitioner herein claims to be a candidate belonging to the OBC category. She had applied for the post of attendant / grass cutter / SYC. For the what is SYC? What is this? I have never grass cutter. For the
Attendant grass cutter and size.
what size?
I am not.
What is size? Where is the advertisement?
But in the mallet.
Where is the advertisement?
32.
32 to 44 mallet.
32, Lordship, last line.
Vacancy post mallet is.
Grass cutter and size.
Is there anything called size?
Lordship,
Check out Google, anybody?
Google or SYCE.
Horse. There is any horse here in Assam. SYC. It must have been going on since British time. Nobody thought important to.
No, in battalions, Lordship, horses are there.
SYC. In terms of advertisement notice dated 31/12/2022. However, the candidature of the petitioner was rejected entirely on the ground that she was overage. According to Mr. Islam, the petitioner, being a candidate belonging to OBC category, was entitled to age relaxation up to 43 years, which was not done in this case. Hence, this read petition. Mr. H. Sharma, Learned
All the respondents.
Additional senior government advocate Assam appearing for all the respondents raised for 4 weeks time to obtain instruction in the matter. Prayer allowed. Issue notice of motion returnable in 4 weeks. Since Mr. Sharma has appeared and accepted notice for all the respondents. No formal notice is required to send in this to extra copy of the read petition with furnished requisite in numbers so as to enable the learned government advocate Assam to obtain instruction in the matter.
In the meantime, further appointment
Entire appointment should be.
The appointment will be made on the 5th of May.
Appointment will happen what to do? One post.
No, Lordship, that's because if we calculate her date of birth is 31/12/79. If we calculate, she crosses 43 in January.
No.
So 40 plus 3 years relaxation, 43 she has already crossed in January.
Age will be counted on 1st of July of 2022.
As per advertisement and on the basis of
Lordship,
that.
outcome of the civil.
Appointment, if any, made during the pendency of the writ petition shall be subject to further orders
Lordship.
that may pass in this case.
May I please, Your Lordship? Matter relates to compassionate appointment, Your Lordship. The petitioner father was working as sub-inspector of police in district executive force, Your Lordship, has been voluntarily retired, Your Lordship, on medical ground, Your Lordship, on 30/6/2009, Your Lordship. Thereafter, he submitted an application for praying for appointment of the petitioner, and the same application was sent to the superintendent of police Dhubri on 14/9/2009, Your Lordship. For placing
Petition
the,
was filed in 2009. Today you want a direction to appoint you.
actually, what happened, Your Lordship, on 23, recently on his visit to the office of the superintendent of police, he was informed that on 23 to 2012, his case was rejected with Lordship kindly peruse page 30, Your Lordship. Without furnishing any grounds, and he has not been communicated to the same, Your Lordship, and the minutes of the DLC has also not been furnished, Your
You
Lordship.
get the.
Matter was not covered by a compassionate appointment, Lordship. His father was voluntarily retired on to 30/6/2009,
All
Lordship.
right, then you will have it for motion again.
Your Lordship, it is covered, Your Lordship.
No,
as per
no,
the
no,
office
not
memorandum
covered, Lordship.
1/5
Voluntary retired, Lordship. He has voluntarily retired.
Counsel for the petitioner. The case of the petitioner is that his application for appointment on compassionate ground was never considered in the correct perspective by the DLC. Mr. H. Chakravarti, learned government advocate, Assam submits that the father of the petitioner retired voluntarily.
Voluntary, Lordship.
And
On medical
therefore,
ground.
this case would not come within the purview of compassionate appointment. Mr. Chakravarti prays for posting this matter again on 10/5/2023. So as to enable him to obtain written instruction in the matter. Prayer allowed. One extra copy of the writ petition be furnished to Mr. Chakravarti during the course of the day. Let this matter be listed again on 10/5/2023 for motion. The father of the petitioner retired on voluntary.
Voluntary, sir.
Then where is the question of compassionate appointment?
As Lordship kindly peruse annexure 14 page 33, Your Lordship. This is office memorandum dated 1/5/2015 plus 2, Your Lordship. Last, I have submitted the type copy, Your Lordship.
Page number?
Page 33, Your Lordship. Page
What
30.
is
Here the dependent family members has been, dependent family member means a person who was wholly dependent on the government servant at the time of the death in harness
Let him
or
obtain, Mr.
or retirement on medical ground.
May I please, Your Lordship? Your Lordship, my senior DP Bora is on leg in division bench, so the matter may be passed over for time being.
Lordship, appeal is pending. Lordship, and I get
Let him come, let him.
Lordship.
Supplementary list for motion item 50.
My Lordship, please. That the private respondent, he was retired from the service, Your Lordship, who was appointed in the registered office of the company with effect from 1st of January 2019. Thereafter, his service was taken after the retirement for a temporary period against an ex gratia payment of rupees 20,000. Now, during COVID, Your Lordship, he discontinued in July 2020. After 25 months, he made a complaint before the Assistant Labor Commissioner on 7/2/2023, claiming 6 months salary. Now, thereafter, on the basis of his letter, the respondent number 2, that is the Assistant Labor Commissioner, under section 10 purportedly hold a call for a conciliation meeting, Your Lordship. Lordship kindly comes to page 33.
Yes.
It's a letter dated 7/2/2023. Claiming 6 months salary. He said salary, but it's a ex gratia payment.
Kindly, my lordship, kindly have a look on page 42 of the notice of the Assistant Labor Commission. This exercise purportedly under section 10 of the ID Act. Your Lordship. Then curiously enough, it turned the entire proceeding under the Payment of Wages Act and passed the impugn order we challenged before this honorable court. Lordship will find in page 46. By exercising power under section 15 subsection 3, directed us to make a payment. That is wholly without jurisdiction, Your Lordship.
No, but why his wages have not been paid for 6 months?
Not, this is a disputed facts that he left, he discontinued from July 2020 during the COVID period 2020. Lordship may recall of that peculiar situation of that. And thereafter he discontinued. There is no question of giving him any payment of execution. Thereafter, Your Lordship, this Payment of Wages Act under section 15(3), that is the extent of applicability. There is a limitation, Your Lordship, under section 1(6), which says the 6,500 rupees is the upper limit. This is number one. Secondly, Your Lordship, under section 15 subsection 2, the application has to be made before the appropriate authority government within a 12 months from the date of the due payment of the wages. Now he has made the application after 25 months.
No, see, COVID period, we are not getting into all these things.
And Lordship, the execution payment, that is not, as per the Supreme Court judgment, not covered under the definition of the wages under section 2(r) of the Industrial
No,
Dispute Act.
that's all right, Mr. Datta. The point is, do you have any material to show that he was working during that period?
Not today, Your Lordship.
I would like to see on
The
what-
question is, Your Lordship, that's just a second item. The question is, the ALC cannot arrogate itself to adjudicate that disputed facts, Your Lordship. That is a whole trouble with the entire procedure.
No, that's all right.
There is a limited jurisdiction, Your Lordship. So there are 4 counts we have challenged this order before this honorable court.
Where is your statement that he was not working since?
Yes, in the writ petition itself. We say that he has discontinued.
But everything was closed during that period due to COVID.
So therefore, he is not a regular employee. He is getting against a work execution payment, Your Lordship. There is no contract, no. Yeah, after the retirement, he is a retired employee. So under the definition of the employee also, he is not covered under the IDA, giving a jurisdiction to the Eastern Labour Commission.
You wait, we'll have to fix it next week again for.
Lordship, the only problem is with us that the Lordship will already have a look into the order, impugn order. He will start the recovery process. That is the whole trouble with us.
What, you will start how?
We will issue a certificate because he having a power
Everything
under
will
the
be over-
act.
Everything will be over by next week.
Lordship is, on the next returnable date, Lordship will examine.
On 3rd, we are fixing it. You tell us on what basis this order has been passed. What is the material? Get your.
Hard, you have a difficulty, Your Lordship.
Then you choose a date. I'm not passing any order today except giving him chance to
Lordship,
show on what basis this order has been passed.
Lordship.
Because ALC will have to have some material to come to a.
Lordship,
conclusion.
only one limited prayer I have made. Till the Lordship will consider the entire matter on motion itself. Lordship may, at that time itself, the ALC may be debarred from taking any recovery process. That only my limited prayer.
I'm not inclined to pass that order till he
Lordship.
gets us some. If he cannot show anything, then of course, yes.
Lordship.
Otherwise.
I understand it. I understand. I understand.
See, there's a poor workman against a mighty management.
Yes, I
You
have
will-
nothing.
They
because
will
this is a
engage
very-
good lawyers like you, come
No,
up
no,
with
no.
technical.
1,80,000.
But we have to be conscious about the reality in this society.
Yes, 1,20,000, nothing, Your Lordship,
You
for us.
50%, 50% you pay, I'll state.
Subject to outcome of
Yes,
this.
subject to outcome.
Lordship.
50% amount you you pay.
No, subject out,
All right,
because we have a right to recovery them.
yes.
Also, just one line is there, just I wanted to point out, page number 46 itself.
Hmm.
Last two penultimate para, in case of any dispute, the same may be raised on 18 April 23 by submitting necessary relevant documents through your authorized representative for disposal. So that whether they have done that, your lordship, that is also.
All right, we'll examine now. He has some difficulty, 50%, subject to payment of 50%.
Sure.
50% of the amount. Heard Mr. B. Dattal and senior advocate appearing, senior counsel assisted by Mr. J. Das, and counsel for the writ petitioner. Also heard Mr. C. S. Hazarika and a government advocate Assam appearing for the respondent numbers one and two. Full stop. In this writ petition, the order dated 10th of April 2023, issued by the respondent number 2, directing the petitioner to pay. Which page is the order?
46.
Directing the respondent, directing the writ petitioner to pay a sum of rupees 43, is it?
46, your lordship. 46.
Yes. Pay a sum of rupees 1,20,000 to the petitioner. As the dues on account of 6 months unpaid wages to him has been put under challenge, inter alia contending that the respondent number 2 did not have the authority or jurisdiction to issue such an order. Moreover, according to Mr. Datta, the claim of the workmen is based on disputed questions of fact, which would not have been entertained by the respondent number 2. Mr. C. S. Hazarika, learned government advocate Assam, on the other hand, submits that these orders are issued keeping in mind the peculiar circumstances during the outbreak of the COVID-19 pandemic, and therefore he will be granted some time to obtain instruction in the matter. Mr. Datta, responding to the said submission. No, you're right. Responding to the said submission of the government advocate, the learned senior counsel for the petitioner submits that unless an interim order of stay is passed, the order would be put to execution. Having considered the submission of learned counsel for both the parties, this court is of the opinion that this matter would call for further examination. First of NOM, hence issue notice of motion returnable in 6 weeks. Since Mr. Hazarika has appeared and accepted notice for respondent numbers 1 and 2, no formal notice is required to be sent to the said respondents. Extra copies of the writ petition requisite in numbers be furnished to the learned government advocate Assam. Petitioner to take steps for service of notice upon the respondent number 3 by registered post with AD within 3 days from today. Heard on the prayer of interim relief. Having regard to the facts and circumstances of the case, it is hereby provided that operation of the interim order dated order is 3rd April, not 10th April. You said
3rd
10th.
April, sorry.
3rd April. P4/2023, issued by the respondent number 2, shall remain suspended, subject to the condition that 50% of the amount payable under the order will be disbursed to the respondent number 3 by the petitioner within 7 days from today, by reserving its right to recover the amount if the petitioner succeeds in the writ petition.
Good.
Payment of within 7 days, huh? Payment within 7 days.
May it please your lordship. Lordship, the petitioner was engaged as an Anganwadi worker, lordship. Annexure 1, lordship. Page 16 is the original, lordship. Along with other 6 persons, lordship, Anganwadi helper and worker on 25th February 2011, lordship. And thereafter, lordship, one title suit was filed by private respondent challenging my engagement, lordship, praying for cancellation of the appointment of the petitioner, lordship. So private respondent challenged by way of filing title suit, lordship.
Where is the order 25-4?
Annexure 6, Lordship.
I'm asking about the page number.
Page number 37, Lordship.
So this order has been passed in compliance of which court's order?
Lordship, from the subject heading the order reference, it appears that it's the title suit and the miss case, page number 28, Your Lordship.
Where is the order passed in the title suit?
Title suit, Lordship, page 20 is the relevant, 19 is the relevant portion, Lordship. Para
Is there
8.
any stay of the decree?
Lordship, stay was not granted, but notice was issued in my miss case, Lordship, stay petition. That I have annexed, Lordship. RSA was admitted, annexure 4, page 29, Lordship. On 9/9/2021. Page 30, Lordship. And miss case notice was issued, Lordship. Page 36. And they have filed another writ petition for execution of the decree, Lordship. That is also pending before this court. And
Writ petition for execution.
yes, Lordship, for execution
Decrees
of
are
the,
executed in writ petitions.
Lordship, it is the case of the private respondent, Lordship. In fact, Lordship, the title suit judgment was passed in the year 2011. And they, by way of an advocate notice in the year 2020, informed that Lordship to execute the decree of the title suit. And thereafter we came to know and we accordingly filed title appeal, Lordship. My condonation was rejected, so I filed this regular second appeal. That was admitted and IA, Lordship, notice was issued. And thereafter they filed one writ petition that is also pending, Lordship. That is WPC number 3669/2021.
I heard Ms. R. Chaudhary, learned counsel for the petitioner. The lead petitioner herein was earlier engaged as Anganwadi worker in AWC number 98 Dasgram under North Karimganj ICDS project, Karimganj. By the order dated, impugn order dated 25/4/2023, her engagement as Anganwadi worker was cancelled by the respondent number Respondent number 4 on the in purported compliance of the order of the court. First of, Ms. Chaudhary submits that although there is a decree passed by the learned civil court in title suit number
127/2011.
127 of 2011 declaring the engagement of the petitioner as illegal. Yet there is an appeal pending against the decree, and the decree has also not been, and the decree dated 23/12/2023 has passed by the civil court has also not been executed till today. Under the circumstances, the respondent number 4 had arbitrarily issued the order dated so and so, that too without complying with the principles of natural justice. First of Mr. C.S. Hazarika, learned Government Advocate Assam, prays for some time to obtain instruction in the matter. NIM 6 weeks since Mr. Hazarika has appeared and accepted notice for respondent number 1 to 4. No formal notice is required to send in this case. Extra copies of the petition will be furnished to the learned Government Advocate Assam so as to enable him to obtain instruction. Petitioner to take steps for service or notice upon the respondent number 5 by registered post with AD within a week from today. Let this matter be listed along with WPC number
3669/2021.
3669/2021, which is stated to be connected with this proceeding, heard on the prayer of interim relief, having regard to the facts and circumstances of the case, it is hereby provided that operation of the impugn order dated 25/4/2023 shall remain suspended until further notice.
I'm deeply obliged.
May I
Your
please?
appeal, your appeal is there.
Yes, my lord. I
Will
have
the
fi-
appeal be disposed of?
Yes, my, and till then, my lord, status quo, my lord.
When did you file your appeal?
On 27/3/2023, my lord. It's almost 1 month, my lord.
Heard Mr. D.P. Bora, learned counsel for the writ petitioner, also heard Mr. S. Datta, learned standing counsel. Revenue and Disaster Management Department, Assam, as well. Mr. D. Bora, learned government advocate, Assam.
2, 3, 4.
Mr. Datta for 1 and D. Bora, learned government advocate, Assam, appearing for respond numbers 2, 3, 4. None is appeared for respond number 5. By filing this writ petition, the petitioner has assigned the selection of the respond number 5 for appointment as Gau Pradhan of 7 number lot, Borpathuri, Sutargaon, under Pakimari Moja in the district of Nagaon. The district of Nagaon, inter alia contending that the respond number 5 does not meet the eligibility condition as laid down in the advertisement notice dated 05/09/2022.
And he is a member of a political party.
Moreover, the respond number 5 is also a member of a political party, active member of a political party,
Political party.
and therefore would not have been appointed as Gau Pradhan system. Mr. Bora submits that questioning the selection of respond number 5, the petitioner had submitted an appeal under Rule 162C of the executive instructions framed under the Assam Land and Revenue Regulation 1886 on 27/3/2023 before the divisional Lower Assam Divisional Central Assam or Lower Assam? Central Assam Divisional Commissioner. However, despite receipt of the appeal, no order has been passed therein till today. Hence this writ petition. Mr. Datta as well as Mr. D. Bora, learned departmental counsel, have submitted in tandem that they would have no objection if the writ petition is disposed of with a direction upon the respond number 2.
my
Respond number 2, to dispose of the appeal filed by the petitioner in a time-bound manner. Mr. Bora has also agreed to such an order, but prays for an interim order of protection till such time the appeal is disposed of. Having heard the learned counsel for both the parties and after going through the materials on record, this writ petition is being disposed of at the stage of motion hearing by providing that the appeal preferred by the petitioner be disposed of as expeditiously as possible, but not later than 60 days from the date of receipt of a certified copy of this order. Till such time, a final order is passed in the appeal, addressing the allegations brought by the petitioner. No order of appointment to be issued in favor of respond number 5 if the same has not already been done.
Deeply obliged.
Obliged, Lord.
Writ petition stands disposed of.
Right, please, your lordship. My lord, this is an IF for modification of the order, my lord. The order, my lord, lordship will find at page 14, my lord. The petitioner, my lord, he was appointed as an Anganwadi worker, my lord. But the order has restrained, my lord, his appointment, my lord. Lordship can find at page 14, my lord. The relevant portion, lordship will find at page 15, the reasons for which the stay has been granted, my lord, restraining my appointment, my lord. Only because, my lord, there's a statement specific observation has been made as she has been working.
Your respond number 5.
Yes, my
Who is for the petitioner?
lord.
Yes,
She is-
my lord, I am for the petition. Wait, please, your lordship. Lordship, she is already eligible and she was working for more than 2.5 years, my lord, 2 years, 4 months, my lord. My lord may come to my page 64 of my writ petition, my lord, kindly, please.
My lord, here is the eligible list of eligible candidates, my lord, and she is in the first, my lord. And she has faced the interview, my lord. She has received the notice that is in page 58, my lord. And after receiving the notice, she had done all the formalities, filing the form and everything. After that, she has faced the interview. And after facing the interview, they has just merrily kicked her out, saying that she is overaged. But her name was in the eligible list. My lord, that is in page 64 of my writ petition, my lord.
So that would may require decision in the. writ petition.
My lord, we have filed a affidavit, my lord. This affidavit, my lord, she is overaged, my lord. She is 44 years. As per the qualifications, her age also not been condoned, my lord. So she has not made any application also before any authority for condoning her age, my lord. She was basically, she could not even participate in the selection process, my lord. She was out from the selection because he doesn't match the age, my lord.
If we go by the advertisement, my lord, she is overage. That is what we.
My lord, I have already been working, my lord, for more than 2 years, 4
You have
months.
not filed any application for
My lord, I have not filed any application, my lord. My lord, I have not received any advertisement also, my lord. My lord, I have only
This
received
matter,
the
writ
notice.
petition will have to be heard. We can't do it today. Heard Mr. G. Alam, counsel for the applicant, also heard Ms. S.T. Wak, learned counsel appearing for the OP writ petitioner. Mr. Ardhar, learned government advocate Assam, is appeared for the official respondent. His IA has been filed with a prayer to vacate the interim order dated
7/12, madam. Page 14.
7/12/2022 passed by this court in WPC number 7591/2022. After hearing the preliminary arguments of learned counsel for both the sides, this court is of the opinion that instead of taking up the IA, the entire writ petition should be taken up for disposal at an early date. In view of the above, registry is directed to list the writ petition. That is WPC number 7591/2022 for final hearing at the stage of admission, for disposal at the stage of admission hearing on 24th of May 2023 as a fixed item. The IAB also listed along with the writ petition. Interim order passed earlier to continue till the next date. Yes.
Obliged, my lord.
You come prepared. If you are overaged, then what can be done?
Yes.
My lord.
Come up with solutions. Don't say that I have been working. So
My lord.
if there is a selection process, selection will take place and you have to fulfill the requirement. Otherwise, you cannot be selected. You did not do anything.
My lord. Obliged, my lord.
May I please your lordship, my lord, this is an application for impleading party respondent, madam.
This IA has been filed with a prayer to implead. Implead whom?
Shakradhar Borua, assistant manager and in charge.
Sri Chakradhar Borua, assistant manager and in charge of Psychota T State in the connected contempt case. Who is appearing for the earlier opposite party? Nobody has appeared.
T does appear, no? Earlier T does.
I perused the statements made in the IA. It appears that the opposite party sought to be impleaded in the connected contempt case is responsible for implementation of the court's order. In view of the above, a prayer made in the IA stands allowed. She so also be impleaded as respondent number 2 in the connected contempt case, and thereafter the contempt case be listed for necessary orders. IA stands disposed of.
May it please your lordship. My lord, I am the writ petitioner in item number 13. I have filed this impleadment petition to be impleaded for impleadment in item number 12, my lord. My lord, what happened, my lord? I am working as Anganwadi worker in Mazgaon, Dakshin Paschim Anganwadi Center under CDPO Bhavanipur, my lord. My lord, and
You have any objection to his?
My lord, no objection.
All right, heard Mr. G. Vaishal, learned counsel for the applicant. The applicant herein is the writ petitioner in the connected proceeding. That is WPC number 6617/2021. And claims to be interested in the outcome of the instant outcome of WPC number 7314 of 2022. As such, this IA has been filed seeking improvement in the aforesaid writ petition. Full stop. Mr. A.R. Sikdar, learned counsel for the petitioner in WPC number 7314 of 2022 submits that he would have no objection if the prayer for improvement made by the applicant is allowed. Full stop. After perusal of the statements made in the application, this court is also of the opinion that the applicant deserves to be implemented, that the applicant is interested in the outcome of WPC number 7314 of 2022, and therefore deserves to be included in the said petition. In view of the above, it is hereby ordered that the applicant Sahida Khatun be included as respondent number 7 in WPC.
6, madam. 6, madam.
6 is child development project.
Oh,
officer.
sorry, madam. Then we'll see.
Don't say something without verifying.
My lord.
Mr.
My lord,
Chairman.
in our petition, my
No,
lord,
no, your petition, I don't know.
subsequently implemented.
Respondent number 7 in WPC number 7314 of 2022, registered to make necessary endorsement in the cost title of the writ petition. IA stands disposed of.
My lord, both the case, our case or their case may be remain tax.
In item 13, you write, let this matter be listed again after 2 weeks along with item 12.
My lord, we'll file our affidavit, my lord,
In the meantime, parties to exchange pleadings. Yes.
in item number 12. Oblige one.
None appears to the writ petitioner on call. This matter stands adjourned for 4 weeks.
May it please the lordship. So in this, the petitioners are employed the Foodcraft Institute. And at the time of their appointment in 2010, they were given salary as per ROP 2010, your lordship. After the coming into effect of ROP 2017, your lordship, they have not given any benefits. And since 2010, they were doing earlier under the earlier ROP. And therefore, they have filed this writ petition, your lordship. And an affidavit to this regard has been filed also.
You don't want to file any rejoinder.
Not required as such because
All right. Then we'll post it for hearing. ROP matter will not take it up in admission. Hearing. When
finance affidavit, even there was also direction that finance should give an affidavit in this regard. That has also not
Because
been given.
our affidavit is simple, madam, that we have forwarded, but finance has rejected it, madam. So
then where is the finance department counsel?
my lord will pass an order. I will inform my lord, Mr. Naik. Finance.
Heard Mr. M. is Laskar, counsel for the petitioner. Mr. R. Dhar, standing counsel.
No, my lord, I am a government advocate, my lord.
Right, Mr.
Yeah,
R.
respondent number
Dhar,
one.
government advocate Assam, appearing for the respondent number 1, submits that affidavit on behalf of.
Respondent number 1.
Whose name should I record?
For 3 I made. Respondent 3 I made.
My lord, finance has to file.
Affidavit on behalf of the respondent number 1 has already been brought on record. Mr. D. Nath, learned senior government advocate Assam, has appeared for respondent number 3. First of, however, since the dispute involved in this petition pertains to claim arising out of ROP, and the finance department of government of Assam has apparently rejected the claim of the petitioner. Hence, affidavit from the finance department would be necessary. However, today when the matter is called up, the learned standing counsel finance is not even present before this court, although the name of the counsel is shown in the cause list. Be that as it may, for ends of justice, 4 weeks further time is granted to the finance department to file affidavit, failing which this matter will be taken up for decision on the strength of materials already available on record.
I'm deployed.
Maybe the lordship, my lord. Yeah, in this case, my lord, the petitioner, my lord, he was awarded some punishment by the railway department. My lord. After departmental proceeding, my lord, I filed an appeal, my lord. Appeal was rejected. After that, instead of revision, I filed appeal, my lord. So they directed me to file revision. When I filed revision, they said there is a time, it has been but by time, my lord. That was rejected. My revision is required to be hard on merit, my lord. There is sufficient down in the department, my lord. That is the only case, my lord. Our calculation, there is no delay actually.
No, but
Because my lord,
what is the time for filing revision?
30 days, my lord.
And you filed it?
According to their calculation, 114 days. My calculation is within time because
What is the
after-
penalty? What is the penalty?
The penalty is reduction of rank, my lord. That is annexure. Yes.
Who is the railway council here?
Mr. S.C. Vishwas, my lord, his legs in code number 21, my lord.
Oh, that is a problem. What to do then?
My lord, punishment page 19, annexure A, my lord, only relevant portion, last one, all like.
Page 19?
Annexure A, my lord, punishment by reduction of pay from present pay to 33 to.
Yeah, but unless Mr. Biswas is there,
Yes, coming.
you call him. You wait for some time.
Yes, fine. Oh, my lord.
Matter pertains to his lordship selection of Anganwadi worker lordship. Right, in a 2012 lordship, advertisement was issued and the petitioner and the respondent have applied for the post of mini Anganwadi worker. And interview held, the respondent number 5 is selected as number 1 candidate and petitioner is selected as number 2 candidate lordship. Thereafter, by the order dated 28/2018 lordship, in title appeal number 7, 2018, the selection of respondent number 5 is declared as illegal. It's page 35 lordship.
So your client has already approved the civil court.
Yes, lordship.
No relief there, then writ petition.
Appointment has not been given till.
Can't be. We'll discuss the petition today. You approve the civil court. That's all. If you don't get relief, that's the end of the matter.
The civil courts decide that partly allowed lordship.
Huh?
Partly allowed.
Also, you implement the decree then. No writ petition. You can't do forum shopping like this. If you've gone to civil court, that's it. Whatever happens, writ petition is not maintainable. Heard Mr. M.K. Neob, learned counsel for the petitioner. Also heard Mr. H. Sharma, learned additional senior government advocate. You have understood what I'm saying. You know.
That's it.
You can't pursue two parallel forums, parallel remedies. Civil court also get a decree, writ court also get something. That's not possible. I'm not dismissing with it this writ petition with cost. That is because Mr. M.K. Neob is appearing. Otherwise, these matters should be dismissed with cost. Unnecessarily using the court's time. So, full stop. Pursuant to advertisement notice dated 22/11/2012, inviting applications for filling up a vacant post of mini Anganwadi worker under the Lakhimpur ICDS project, the writ petitioner and the respondent number 5 had both submitted their application. Full stop. Eventually, the respondent number 5 was selected as she ranked higher than the writ petitioner in the merit list. Full stop. Aggrieved thereby, the petitioner filed title suit number 7/2015 before the court of Munsif number 1 Lakhimpur, challenging the appointment of respondent number 5 on the ground that she was not a resident of the Anganwadi center and hence did not fulfill the eligibility condition. The suit filed by the petitioner was dismissed by judgment dated 28/3/2018. Full stop. Thereafter, title appeal number 7/2018 preferred by the petitioner was partly allowed by order dated 18/12/2018. Full stop.
And declaring the selection of respondent number 5 as illegal.
Declaring the selection of respondent number 5 as Anganwadi worker as illegal. Full stop. Thereafter, the petitioner has approached this court by filing the present writ petition, seeking a writ of mandamus. Full stop. The point that is worth noting herein that the grievance expressed in the writ petition was agitated by the petitioner in the, before the civil court, wherein the first appellate court had partly decreed this suit, full stop. Situated thus, it would not be open for the petitioner to now pursue a parallel remedy before the writ court, full stop. Remedy, if any, would lie in pursuing the decree passed by the first appellate court or preferring an appeal before a higher forum for modification of the decree, if so advised, full stop. Therefore, this court is not inclined to entertain the writ petition, being a parallel proceeding to the civil court proceedings instituted by the, being a parallel proceeding to the proceedings instituted before the civil court by the petitioner on the same cause of action. This writ petition is accordingly closed by granting leave to the petitioner to pursue appropriate remedy in the matter. You seek enforcement of the decree. Why have you come here? The writ court is turning to be an execution court of civil court decree. These are very wrong things.
Sorry, but.
Yes, Mr. Biswas, why don't you consider his revision petition?
My lord, what happened, my lord? That money has already been deducted from his salary. That is the punishment.
Yes.
He was reduced to some amount to his salary. And now he is getting original salary. Now what happened? The revision was rejected because of it is delayed by 114 days.
So then
Time bar.
money has already been deducted.
Yes. Now he is getting regular scale.
So we'll hear the matter and discuss. Why again you want to go to revision court?
Oh, no, only one thing. We filed appeal, initially we filed appeal, then revision matter on merit of that our.
He has not challenged the punishment.
No, punishment.
Department proceeding he has not challenged.
No, my punishment I have not challenged in this case. In this case, only my right of my lord revision, my lord, because kindly say only one thing, my lord. It was not
It doesn't
decided on
happen
merit.
like that. It doesn't happen like that.
No, my lord, the imperial said, my lord, it was not decided on merit, my lord. As per their instruction, I filed revision, my lord. And now they are saying.
Mr. Chaudhary, law doesn't go the way you are perceiving.
Here, my lord.
So
Here, my lord.
if we want to decide the matter, you will stop us.
No, of course not.
I want to decide the case, whether the punishment is valid or not. I'll decide it today, but you have not challenged it.
No, I have not challenged it.
Then what to do?
But here, my lord, I filed revision. but
I
that was-
understand this was your idea,
Yes.
but that is not how law works. You have to challenge the order once it is, you can't come to the court and say, give me an order that my revision should be heard. You have to say, I am aggrieved by the order of punishment. This is a relief the court will mold. You can't dictate the relief to the court.
Yes.
So you are left nowhere. You have only option to withdraw the writ petition and file afresh. Otherwise, nothing. I'm sorry to say this. You have miscalculated it. This is not how it is done. You can't file a writ petition saying, I want a direction for disposal of my
Because
representation.
that was pending, my lord. That
On the
was-
prayer of Mr. H. Chaudhary, learned counsel for the petitioner, this matter stands at.
My lord, we will do it. I will do it.
Yes.
We'll
There
do
would
it.
be-
Mr. H. Chaudhary, learned counsel
challenge
for the petitioner submits that when the writ petition was filed, the only relief the petitioner sought was an order for decision in the revision application filed by him by the appropriate authority. However, since the amount has already been deducted and the revision petition has been rejected, and the respondents have declined the application for revision, he be granted leave to withdraw this writ petition with liberty to assail the order of penalty imposed upon his client with a request to the court to decide the matter on merit. Mr. S.C. Biswas, learned standing counsel, NF Railway is present and does not have any objection if the prayer is allowed. In view of the above, this writ petition stands disposed of and withdrawn with liberty as patron. You have to challenge everything. It is for the court to mold a relief. You can't dictate the court what relief should be molded. You have to ask for everything.
Yes.
You read order to rule 2, your petition is actually barred. The principles in order to rule 2 CPC will
Yes,
apply.
CPC, you have to put
Yes.
everything at the.
You have to
at the
pray
first-
for everything. What the judge does is his concern. You can't dictate that. That no, now I want this, then again I'll come.
Yes, definitely.
These are not good lawyering. Yes.
All right.
May, so the petitioner here in his lordship agree by recovery of excess drawn amount.
Lordship,
Yeah.
I have received inspection,
Admitted.
Lordship. It appears that he is entitled to the revision. His pay has to be fixed on the basis of, on the post of Nayak, Lordship. If the department sends us the paper to us, we can. Earlier, we calculated the pension on the basis of the paper sent by the department, Lordship, in which the recovery part was mentioned, Lordship.
Actually, without considering the revised pay, lordship, they have fixed my salary. Lordship.
So if written to the department to send afresh the service book, Lordship.
I am drawing lesser amount of pension, number one. Secondly, they have recovered excess drawn amount, which was done without fixation of my pay. 1,56,000. That is my fare.
All right. How much compensation?
Lordship.
Who will pay him the compensation?
No, Lordship is getting the pension, only the
No,
lower
but
scale.
Lower scale.
Only the lower.
But why?
Margin, I think the
Why
difference.
somebody who, that is not his mistake.
No, Lordship. So that is not our fault, Lordship. It's a department only, Lordship.
So you tell us what compensation we will pay him.
Lordship, no, it was.
It has to be paid.
No, we did the calculation, based on what the AG has stated.
You sort it out. Who will pay the compensation?
Actually,
Only 1 week's time for that.
humbly state that, let the.
Lordship means kindly appreciate that we did not contest that suit the case, Lordship.
No, but whoever is responsible, he has suffered. If you cause injury to, see the norms of civil society, civilized society is that if somebody suffers injury because of a wrong deed, he has to be compensated.
2019,
Go on like this.
retired on 31st of August 2019.
So amount will carry interest and you tell us the officer from whose emoluments it will be recovered.
Lordship,
That's
I kindly appreciate it's not an old case also, Lordship. It's retired in 2019, Lordship.
You can these things, people blindly depend on the government.
Lordship. That's
Courts
true.
pass orders and
That's
the
true,
government calculation. Courts, we take it as gospel truth when the government comes up with a stamp. Unless the materials are placed to show that it is not correct, the court accepts it. This is the case with millions of citizens. How can the government make him suffer like this? Who is responsible for this? Somebody is responsible for this. Mr. Azhar,
Lordship,
it can happen to anybody.
Lordship.
When somebody is made to pay the price, then things get organized.
Not intentional.
Give the name, give the name.
It was not intentional, Lordship.
No, you give the name.
Secondly, your Lordship, Lordship, one affidavit.
We don't want others to suffer for this. The officer who is responsible. give his
Lordship,
name.
we find an affidavit, your Lordship, it is with e-filing, the e-filing is there, but somehow it is not there possibly, your Lordship.
Where is your affidavit?
Lordship, we had, that is what I'm saying, also we e-filed it, but whether it is there in the A file, in the B file, I have seen that it is not there, it's not been here. E-filing is there, your
You
Lordship.
file your affidavit. Who are you representing, Mr.?
The commandant has filed an affidavit.
So already respondent number 2 and 4 has already filed affidavit. 2 and 4, 2
What
is
for?
lordship. Yes, 2 is lordship, the Director General of Civil Defense and Commandant General of Home Guards. They have filed, and 4 is Commandant ASRF. So they have already filed.
You are appearing for?
Accountant General, respondent number 3, Lord.
Who is representing 2 and 4?
I am. Lordship,
Yes, this is the affidavit they have filed,
I filed the affidavit, your Lordship.
and they have admitted lordship.
We'll close the matter then. Within 15 days, failing which the amount will carry interest.
Lordship,
To be recovered from the hearing
Lordship.
officer. Heard Mr. A. Deka, learned counsel appearing for the petitioner. Also heard Mr. B. Chakravarti, learned CGC appearing for the respondent numbers 1 and 5.
On respondent number 3 only, Lordship. Standing counsel AB, Lordship.
Respondent number 3, Mr. C.S. Hazarika, learned, you are appearing as CGC.
No, your
No,
Lordship.
CGC is not a, I'm as a standing counsel in AG, Lordship.
I am for the, I am 1, 2 and 4, your Lordship, police.
Government Advocate Assam, has appeared for respondent numbers 1, 2, and 4, and Mr. H. Earlier for
Respondent number 5.
respondent number 5. The read petitioner has retired from service in the post of Havildar.
Yes, Lord, I will. I was promoted in 2011 annexure one.
Forget promoter, nobody wants to know that.
I will do on
Havildar at ASRF BN-1 Burma with effect from 31/8/2019. After retirement, the pension of the petitioner was apparently fixed at a lower scale. That is by ignoring the increments, by including the revised pay scale. So not only that, some recovery was also
Yes.
made from the.
So
petitioner.
annexure 13, page 39. From my DCRG amount, they have already recovered. Annexure 13, page 39. 1,33,337.
Page 39.
Page 39, annexure 13,
Not only that, a sum of rupees
in the middle portion, total recoveries.
1,33,337 has also been made from the DCRG of the writ petitioner on the ground of excess drawing. Full stop. Aggrieved thereby, the petitioner has approached this court by filing the instant writ petition inter alia contending that there was no actual excess drawal by him. On the contrary, he has been deprived of the actual amount of pension which was not worked out on the basis of correct pay scale. Full stop. On receipt of notice issued by this court, the learned counsel for the respondent number 3, that is the Accountant General Assam, has produced written instruction dated 22/11/2022, according to which there was a mistake committed in fixing the pension, in finalizing the pension of the petitioner at a lower scale.
Lordship,
Although-
we calculated the pension on the basis of the paper sent by the commandant.
Although the petitioner was entitled to pension at a higher scale. Full stop. Mr. Chakravarti submits that the mistake was committed due to incorrect information furnished by the respondent numbers 1, 3, and 4. Full stop. Mr. Chakravarti has further clarified that the recovery made from the DCRG of petitioner was also not proper, as there was no excess drawal on his part. Full stop. Submitting that the error will be rectified as soon as the papers are sent by the administrative department. Mr. Chakravarti assures this court that the grievance of the petitioner will be redressed without any further delay. Full stop. Mr. C.S. Hazarika, learned counsel for respondent numbers 1, 3, and 4 also submits that it is a case of unintentional error on the part of the departmental authorities, and therefore immediate steps will be initiated for rectification of the same. Stop. Responding to the query of this court as to who should be held liable for the injury caused to the petitioner for the mistake committed at the departmental level, Mr. Hazarika has submitted that since the error was unintentional, the court may show leniency in this matter for the present. Full stop. Taking note of the submission of learned counsel for all the parties and by retaining a copy of the written instruction dated 22/11/2022 submitted by Mr. Chakravarti, this writ petition is being disposed of by granting 2 weeks' time from today to the respondent numbers 1, 3, and 4 to forward the papers to the respondent number 3 for rectification of the mistake in fixation of pension of the petitioner. Full stop. Mr. Chalia, learned counsel appearing for the respondent number 5, has also assured this court that all necessary support in this regard will be extended for rectifying the mistake in finalizing, in fixing the pension of the petitioner.
No, Lordship, from within 2 weeks, they will forward to us. Within 2 weeks, we'll take action, Lordship.
Mr. Chakraborty has also assured that within 2 weeks after receipt of the papers, necessary action for redressal of grievance of the petitioner will be taken.
They will forward to us. So we'll-
Understood. Um, In view of the above, this writ petition stands disposed of by directing the respondents to do the needful to rectify the defect in fixation of pension of the petitioner within the time schedule as noted above. It is made clear that if for any reason the defect is not rectified within the time prescribed by this court, it will be open for the petitioner to approach this court again, seeking compensation for wrongdoing, if any, on the part of the respondent. Writ petition stands
Lordship,
closed.
regarding repayment of that excess roll amount.
The respondents will
1,33,000.
necessary steps for refund of the excess, refund of the deducted amount, along with you pay interest here.
Yes.
Interest at the bank interest at the rate of 6% per annum with effect from the date of deduction till refund of the same. With the above observation, writ petition stands closed. Yes.
So we did a time frame.
6% you have to give him interest.
So we did a
Month.
time frame, Lordship. Within a time.
Oh, within 2 weeks. It's been mentioned. 2 weeks for them to forward
Yes.
the papers and 2 weeks here. Otherwise, you come back. This time we'll fix liability.
Deep problem. Oblige, Lordship.
Mr. Lordship, this is subsequent repetition on the stance of the order dated 5/12/2017 passed by the
I have
Senate.
received the instruction, Lordship. It has been rejected, Lordship. I have to file my affidavit, Lordship. It has been rejected.
I heard Mr. M.S. Ali,
Yeah, I'm
counsel for the petitioner. Also heard Mr. S.S. Roy, learned government. advocate,
CGC.
learned CGC appearing for the respondents who submits that he has received instruction in this case, according to which the prayer of the petitioner has been rejected.
Lordship.
And therefore, be granted 2 weeks time to bring the same on record in the form of an affidavit. Prayer allowed, list this case after the affidavit is filed.
Oblige.
The Council for the Indian Agriculture, Council for Agriculture Research, my lord. ICAR. The pleadings are otherwise complete, my lord. This pertains to, my lord, employees of KVK, Kisan Vikas Kendras, which is controlled by the ICR, but operated through, my lord, host institutions like the Agriculture University. Now, there are two scales of payment. One, my lord, they have given us an option where we opt for ICAR's pay scale, or, my lord, we go for Assam Agriculture University pay scale. Now, we all opted for ICAR pay scale. Now, under the ICAR pay scale, my lord, all over the northeastern region, there are some emoluments given. Like,
Who is appearing for the
my
ICAR?
lord, lady, my lord, she normally appears for the matter. She has filed the affidavits also, my lord. But unfortunately,
Then we'll have it on some.
my lord will have, because pleadings are complete, my lord can have it.
Mr.
on a
You can
confidential-
have a senior counsel appearing for the petitioner in both these petitions submits that pleadings are complete in these cases and therefore the matters can be taken up for disposal. However, Mr. L. Das, is it?
My lord, I appear for the Agriculture University, respondents 4 to 6.
Mr.
A. Borua.
Mr. A. Burwa, learned counsel has appeared for the respondent numbers 4 to 6 and submits that the matter is ready for final hearing and disposal. However, the learned counsel for the ICAR appearing for the respondent numbers 1 and 2 is absent today.
1, 2, and 3.
1, 2, and 3 is absent today. Full stop. Considering the nature of issue involved in this petition, the counsel for the respondent number 1, 2, and 3 would have to be heard before a final order is passed in this matter. For ends of justice and in order to give the learned counsel one more opportunity to appear, registered to list this matter again on 23rd of May.
Lordship.
2020.
Much
These
obliged.
matters. 23rd of May as fixed items.
This is regarding compassionate appointment, my lord. Since DLC has already recommended, my lord, only SLC has rejected the proposal of the petitioner, my lord, saying that non-availability of vacancies as per roster register. Since, my lord, this honorable court division bench also held that, my lord, when the DLC has recommended against this, the vacancy post, the SLC has no right to say about the non-availability of vacancies, since against the vacancy it was already recommended. So since in earlier occasion, my lord, I have supplied your
What
lordship.
is your stand? Your lordship, only in a point of law of delay. That SLC rejected in the year 2015. And he approached in the year 2022. 7 years, your lordship. I like to place one judgment.
DLC has recommended there was a vacancy.
As per the DLC, there was a vacancy, but the SLC, they rejected it on 3 grounds at page number 37. Para 9B. Non-availability of vacancies as per roster register. Para 9B. Third paragraph. Non-availability of vacancies as per roster register, overage, and non-occurrence of vacancy within 2 years of submission of applications.
Mr. Chetri, these matters will bunch up in here. No order can be passed today. Heard Mr. BK Chetri
No.
and council.
Since it is not in my case due to overage, my lord, this is not my case. Only
No, this court has already expressed opinion that whether these applications can be considered after years together. is a
No,
matter.
that part, my lord, since I have stated, my lord, para 11, my lord.
Mr. Chetri, today you want the order. It will be only an order of dismissal. It's better for you to wait.
As
I'm
your
not
lordship.
inclined to allow mandamus in these matters. Unless there is a very strong case made out. People are coming 1997, 98, we can't, there has to be some principle. There has to be some principle, we have to give a relook at this compassionate appointment matter. We have asked the government to line up things. You have to wait.
And whatever point here, my lord, as your lordship, please.
Because what happens is direct, then again come back, direct, then again come back. This is all going on.
That
Every
issue,
compassionate matter, 4th, 5th, 6th round of litigation is
that
happening.
issue already been resolved by the honorable division bench, my lord.
Which case? Show me the judgment.
This 2018 lordship,
Yes, what is it?
that part already I supplied.
Which judgment?
This is Aziz Zaman Borguya, my lord.
Yes, what is the point decided?
Para 4 lordship.
Yes.
Application made by the appellant for appointment on compensation ground well within time on 7/10/2009 was brought to an end only on 11/8/2017. The inordinate delay in the disposal of the application certainly cannot be attributed to the appellant. Further, non-application of mine is also demonstrated by the state level committee in rejecting his case due to want of vacancy when an exercise had already been conducted by the district level committee certifying the suitability of the appellant and existence of vacancies in the post of forest guard under the establishment of the divisional forest officer, social forestry division, Silchar. Rejection of an application without due application of mine and as a matter of course and by employing the expression want of vacancy and spend its force are easy methods to deprive a candidate from his legitimate entitlement. Such course of action would only go to frustrate and defeat the very object governing compensation appointment. This shortcomings finds best illustration in the present case where the candidature of the appellant was rejected for want of vacancy despite favorable recommendation being made by the district level committee having regard to the existence of vacancies and on ground of elapse of time for which the appellant cannot be found fault at. On facts above, we are of the considered view that the case of the appellant for appointment on compensation ground was not handled judiciously and by going into the merits of this case. Rejection merely on technical grounds and on ground of want of vacancy does not find support from available record. It also doesn't inspire the confidence of this court. We allow this writ appeal and set aside the order so and so with a direction to the Secretary of Government so and so the department to place the case of the appellant before the state level committee in its very next sitting.
So according to you, your case is covered by this judgment. Is it covered
Since
by the judgment?
They are saying inordinate delay, 6 years, my lord. That was.
What do you have to say?
Your Lordship, I'd like to place one latest Supreme Court judgment dated 23rd of 3rd of March 2023. Just para number 7.3, 7.4 and 7.5. I have like marked that particular page also, Your Lordship, at the bottom.
7.3.
7.3, 7.4 and 7.5. More importantly, para 7.5 is the part which relates to the issue of delay. If I may read out, Your Lordship.
Yes, please.
Considering the second question referred to above in the first instance regarding whether applications for compassionate appointment could be considered after a delay of several years, we have to view that in a case where reasons for prolonged delay, either on the part of the applicant in claiming compassionate appointment or the authorities in deciding such claim, the sense of immediacy is diluted and lost. Further, the financial circumstances of the family of the deceased may have changed for the better since the time of the death of the government employee. In such circumstances, courts or other relevant authorities are to be guided by the first fact that for such prolonged period of delay, the family of the deceased was able to sustain themselves most probably by availing gainful employment from some other source. Granting compassionate appointment in such a case is noted by this court in Hakim Singh would amount to treating a claim for compassionate appointment as though it were a matter of inheritance based on a line of succession, which is contrary to the Constitution, since compassionate appointment is not a vested right and the same is relative to the financial condition and hardship faced by the dependents of the deceased government employee as a consequence of his death. A claim for compassionate appointment may not be entertained after a lapse of a considerable period of time since the death of the government employee.
No, that, my lord, to approach the honorable court after lapse of several years, my lord. But my case, my lord, immediately I approached within a month, my lord. That part in initial stage, now.
You wait, Mr. Chetri, we'll like bunch up all these cases and
Lord.
take a decision. There are contradictory judgments.
Lord.
Things have changed.
This may not be applicable for me.
Mr. B.K. Chetri and Council B. Chetri and Council for the petitioner, Mr. B. Bora, government agency. The prayer that the petitioner is aggrieved by rejection of
Directly approach for
his case for appointment on compassionate ground, entirely on the ground of delay. The application was submitted by the petitioner in the year 2015.
18.
Look at the record and submit when you are in the court.
No. He approached.
Application was
this is-
submitted when?
This is citation, my lord,
15.
2018.
15 itself.
No.
They filed the application on 2015, annexure B1, Your Lordship.
Citation, regarding citation, lordship is saying about citation.
No, application filed by the petitioner. He filed the application for compassionate appointment in the year 2015.
Person died in 2014 and 11/7/14.
So the application was rejected by the SLC in 2015 itself.
No.
15 itself.
15. And I have come to know para 11, my lord.
It appears that the application submitted by the petitioner seeking appointment on compassionate grounds in the year 2015 was rejected by the SLC in its meeting held on 30/12/2015.
The petitioner has come to know, my lord, on 8/12/2021, my lord.
According to the petitioner, he came to know about the
About the
decision
rejection.
of the SLC only on 8/12/2021,
2021.
2021, whereafter the writ petition has been filed. Full stop. Whether the application of the petitioner has been rejected on valid grounds, and if not, whether a writ of mandamus will lie at this stage for appointment of the petitioner on compassionate ground throws up many questions which have to be decided in the light of judgments which are available on this issue, expressing diverse opinion. First of all, registry is therefore directed to list all such matters together where question of delay in consideration of applications for appointment on compassionate ground is concerned. These applications be listed in a bunch. These writ petitions be listed in a bunch on 6th of June 2023. We'll decide all these cases together, 6th of June.
On the same issue, my lord, already single bench, this
Single
honorable
bench,
has also been
Supreme
decided.
Supreme Court has two different views. Forget other bench.
So-
Supreme Court has had two different views.
different views, my lord, to approach
No,
in the
nothing,
initial stage. my lord.
nothing. Within 1 year, if the appointment is not given,
Yes,
it is over.
that part, my lord, we have done it.
Appointment has to be given within 1 year.
Lord.
Compassionate appointment is immediate. Otherwise, you have to go through the scheme first. What is
That's-
the purpose of the scheme?
Yes,
The Supreme Court is right in saying this is not an inheritance scheme. Somebody died, so till the time I get appointment, I'll keep thumping. That is not how it is.
and moreover, my lord, our case, my lord, in Guwahati High Court, my lord, what we have seen, my lord, this single bench Achyut Ranjan Das case is squarely, there are some guidelines, my lord, according to that
We'll see,
guidelines,
we'll examine, you address arguments.
we are before.
Let's see, but the fundamental principle is within 1 year, appointment has to be given.
And
If
since
it cannot be given, it's over.
this is only on the part of the government, sometimes, my lord, they are not
So
giving.
therefore, the mechanism has to be better than.
2022.
The
Yes, my lord.
mechanism has to be.
Yes,
better.
yes.
Yes.
May I praise your lordship? Lordship, this matter pertains to, lordship, wherein our appointment as forester grade 1 was cancelled, lordship. We were promoted and the appointment was cancelled. Lordship, affidavit was required to be filed. Till date, lordship, nothing, no affidavit is very.
My lord, we'll need some more time to file the affidavit. My lord, I prefer 2 weeks.
Lordship, this matter is pending since August. Lordship, I understand, lordship, they were promoted.
4 weeks, last chance.
Lordship,
Had
it's the last
Mr.
chance.
Chakravarti, Learned Counsel for the petitioner. Also had Mr.
A. Borua, my
A.
lord,
Buddha, Learned Counsel appearing for the,
Forest Department, respondents 1 and 2.
that is respondents 1 and 2, please for further 4 weeks time to file affidavit. Prayer allowed. It is however made clear that no further adjournment for filing affidavit will be entertained in this case.
I'm
This is the
obliged.
matter according to.
In this case, I have received the paper. I will be able to file my affidavit next week, lordship.
Mr. Chakravarti has appeared for the petitioner on the request of Mr. B. Chakravarti, Learned Counsel for the.
CGC, lordship.
These matters stands adjourned for 3 weeks so as to enable him to file affidavit.
Obliged, lordship.
Please, your lordship. So this matter relates to compassionate appointment, lordship.
My lord, I have received the instruction. This also has to go to the bunch. 2 grounds, my lord. His father died in 2012. He made an application in 2017. Why? Because he was minor when father died. 2 grounds. And even, my lord, in his thing was again considered in 2nd of March 23, again rejected. That's a new.
So we'll have these cases listed.
Yes, my lord.
One category where delays because the applicant was minor.
Minor.
One category is delay in disposal by the government. One category non-availability of vacancy and hence delay. So all delay matters will bunch together. And we'll see if the mechanism laid down in Achyut Ranjan Das's case requires further readjustment.
Yes.
But the point is now that scheme has been discontinued. It is only a
Yes.
question of family pension.
Family pension now.
So all these
2017.
matters, how it is to be dealt with, we can't go for an ad hoc thing. The orders are passed, reconsider, what purpose will be served? Anyway, what is your stand here?
My lord, I will file an affidavit, though apparent, my lord, this is the instruction, my lord, for almost 5 years delay of filing this application. That ground is
Mr.
gone.
R. Pokon, Learned Counsel for the petitioner, also heard Mr. R. Dhar, Learned Government Advocate Assam, who submits that there has been delay in filing the.
And he was a
application by
minor.
the petitioner,
When
And therefore his claim is barred by law. However, 4 weeks time be granted for filing affidavit. Prayer allowed, let the matter be listed accordingly.
Obliged.
May please the lordship. My lord, in this case, the petitioner Lordship was appointed as block MIS manager on my lord 1/3/2016. Thereafter, my lord, his service, contractual service was terminated. The termination order was silenced before this honorable court. This honorable court set aside the termination order, directing the authority to reinstate the petitioner in service. He has been reinstated in service, but the benefit of his past services has not been given to the petitioner.
Current salaries, you have not paid salary.
Salary has been paid.
Salary.
Salary has been paid, but from the date of my reinstatement, they are counting my service. Had the service been counted from the initial appointment, then my salary would have been different. My lord.
So that to affidavit they will have to file. You file affidavit,
Yes, Lordship.
huh?
but,
You file.
Waiting for instructions.
The block, my lord, Lordship will kindly see page 31.
This matter can't be disposed of without an affidavit. Can it be?
So need more time.
Video has admitted.
Huh?
Video has admitted, my lord.
Where is the admission?
Page 31, my lord.
The bid. You are agreeable to disposal of this matter.
No, Lordship, we'll file affidavit.
Had Mr. Ayub Sekal and counsel for the petitioner also had Ms.
And Bora.
Standing counsel PNLD Assam who prays for further 4 weeks time to obtain his consent and file affidavit. Mr. S.S. Roy and Government Advocate Assam is present on behalf of the state. On the request of Ms. Bora, this matter stands adjourned for 6 weeks so as to enable her to obtain instruction and file affidavit. Next date will dispose it of.
On this.
Yes.
This matter, Lordship, we need some more time to file affidavit.
You are for whom?
For respondent 1, 2, and 3, Lordship, Higher Education Department.
Lordship.
Mr. R.D. Ms. R.D.V. Learned Counsel is present for the petitioner. Mr. A. R. Tawildar, Learned Standing Counsel, Higher Education Department, Assam, appearing for respondent numbers 1, 2. 1, 2, and 3. Praise for 4 weeks time, further 4 weeks time to file affidavit. Who is for 4 to 7?
Lordship, I am appearing for the Health Department, Lordship.
Mr. Due Commitment, Learned Standing Council, Health and Family Welfare Department, Assam, appearing for respondent numbers 6.
Lordship, not 6, only 6, Lordship. 6 and 7. 7,
7,
8, and 9. Yes.
Also makes a similar prayer. In view of the above, let this matter be listed again after 6 weeks. In the meantime, affidavit on behalf of the respondents be brought on record. Yes.
Time may be continued.
Huh?
In time may be.
Interim order passed earlier to continue.
Obliged, Lordship.
Here we are challenging the order of removal from service. As it is a case of disciplinary proceedings, probably affidavit will not be much of a requirement if they get the
No,
records.
if affidavit is ready, my lord, the SP is coming. Next week we are filing the affidavit, my lord. And we will also put in the record.
Petitioner is present, yes, yes.
Okay.
Mr. D. Nath, Lanet Senior Government Advocate, Assam, submits that affidavit on behalf of the,
The respondent number 4, my lord.
on behalf of respondent number 4 is ready and shall be brought on record
Next week, my lord.
during the course of next week. In view of the above, let this matter be listed again after 2 weeks by tagging the affidavit with the record of the case. The read petitioner may file rejoinder in the meantime, if so advised.
From next week.
Matter relates to the pensionary benefits to the petitioner. In last occasion, they took 2 weeks time to file affidavit matter.
Affidavit by the irrigation department is necessary.
Who is appearing for the irrigation department?
Matter is almost finalized procession, my lord. I have come to know, I have annexed the document also, but they are delaying the matter, my lord. I take your lordship, one annexure, my lord, it will help your lordship. My lord, at page 39, kindly see, my lord.
Nothing will work out till the department will
Yes,
counsel.
my lord, that's my lord.
Will you get him? Get the irrigation council. Can you ask your junior to ask him to come? Or you want it to be posted some other day?
Any other day, my lord.
Right, I had Mr. S. C. Biswas, Learned Counsel for the petitioner, also had Mr. A. Hassan, Learned Counsel appearing for the Respondent number 6. That is respondent number 6, Mr. A. Chakraborty, learned Government Advocate Assam is present on behalf of the respondent number 5. However, the grievance expressed in this writ petition cannot be considered in the absence of learned Standing Council Irrigation Department Assam, who is absent today. As such, let this matter be listed again after 10 days, so as to enable the Standing Council Irrigation Department Assam to put in an appearance.
Obliged.
Item 31.
My pleasure, Lordship. Lordship, this matter pertains to Lordship. We were placed under suspension, Lordship. Thereafter, inquiry committee was constituted. Inquiry committee arrived at a finding that no conclusion could be drawn based upon the materials on record, and the further proceeding will be subject to the outcome in the criminal case. Now, Lordship, I am due for retirement on 30th of April, Lordship. The period of suspension has not been regularized based on such findings, Lordship.
My lord, I received a 2-line instruction, my lord. DP is still pending and that suspension period is not regularized. That is my instruction, my lord.
So you will, in any case, you can't get pension right from day one. You will get provisional pension.
Lordship, I understand.
So we'll take it up for disposal, then we have to pass an adjudicated order. You don't want to file any affidavit.
No, my lord.
But I heard Mr. A. Chakraborty, learned counsel for the petitioner. Also heard Mr. R. Now learned Government Advocate Assam, and learned Standing Council PWD Assam, who has obtained instructions in terms of the order dated 21/4/2023 passed by this court, and submits that since a DP is still pending against the petitioner, hence no order for regularizing his period of suspension has been passed till today. Full stop. Mr. Chakraborty, on the other hand, submits that his client is retiring from service with effect from 30/4/2023 on attaining the age of superannuation, and therefore appropriate order is required to be passed in this case by this court, so as to ensure that his pensionary claims are not frustrated. Full stop. The aforesaid aspect of the matter would call for detailed examination, for which affidavit on behalf of the respondents would be necessary. As such, this matter is directed to be listed again after 4 weeks, so as to enable the department to place its stand on record on affidavit, including projection as to the period that would be required for concluding the departmental proceeding. First of, since the petitioner is retiring from service with effect from 30/4/2023, and there is no order of penalty imposed against him as on date, it is made clear that necessary steps for payment of provisional pension to the petitioner would be taken without any further, would be initiated by the respondent, by the concerned authorities, without any further delay in the matter.
Obliged.
Without any undue delay in the matter. Provisional pension in accordance with law, without any undue.
Also, this matter pertains to appointment on compulsion ground. Lordship.
Yes.
Lordship may peruse order dated 7/9/21.
What are you arguing for? Final disposal? What is the ground of rejection?
Lordship, what happened? My case ought to have been considered under the 2009 scheme, but my case has been considered under the 15 scheme because my father expired in the year 13. Immediately I applied. At that relevant point of time, the 2009 scheme was in vogue. So, at the DLC.
What is your stand?
Your lordship, there is a recent Supreme Court judgment, a 3-bench judgment, wherein it says that the date of consideration of the application would be the day on which that application, which the OM which is actually prevailing on that particular date. That would apply. NC Santosh versus State of Karnataka. I don't have a copy of the judgment today. If your lordship lists, I have a soft copy. So if your lordship lists it day after tomorrow or any other date, I'll place that judgment.
Only what happened, Lordship, my case has been recommended by the DLC. And the SLC considered my case under the 2015 scheme. DLC recommended my case.
And this honorable court has passed.
Mr.
an
S.
order-
Chakraborty, Learned Counsel for the petitioner submit that although the petitioner's case was recommended favorably for appointment under the 2009 scheme,
Lordship,
yet the SLC has considered this case under the 2015 scheme
Lordship.
and erroneously rejected it, although the petitioner was entitled to benefit under the 2009 scheme. Full stop. Responding to the above, Mr. D. Bora, learned Government Advocate Assam submits that in view of the recent Supreme Court decision, it is the scheme in vogue on the date of consideration that alone would be applicable. Full stop. The learned Government Advocate Assam prays for posting this matter again after 2 weeks so as to enable him to address the court on the legal point. Full stop. List the case, prayer allowed, let the matter be listed accordingly. You also look at the judgment. and
Okay, I'll
address
go
arguments.
through.
Yes,
Is
This-
2027 SCC 6.
give him the citation.
2027 SCC 6.7.
6.7, no?
Yes.
Lordship, 53 is similar to that earlier matter. It may be listed on 6th of June, same delay ground.
Mr. Chetri, this is also delayed
Not delayed.
compassionate appointment.
Compassionate appointment, but matter relates to this similar to the Bhaskar Kumar case, my lord. That since balancing service of 3 years, my lord.
Actually, those matters are sent for reconsideration.
Your Lordship, here also, the SLC rejected in year 2015.
No, but the ground is he did not have balance of 3 years.
Yes.
But here, the ground is non-availability of vacancies as well, roster register. That is the case.
It is not the
They
case.
have taken their own writ
That
petition.
part is complete. He has not seen the actual. The speaking order, you see the speaking order, 43.
Anyway, today there is a division bench again at 1 o'clock.
Yes.
If it requires application of mine, then we can post it next week.
40, yes, 44, my lord. This is government employee had less than 3 years of service, hence inconsistent.
Mr. B. Chetri, I will counsel for the petitioner. On the request of Mr. D. Baran, I will government Advocate Assam, let this matter be listed again on 9th of May. 9th of May 2023 as a fixed item. 9th of May.
For orders, item 37.
Send up here my cause list as possible.
Lordship, during the pending as per information from.
My lord, against this, the order of the honorable single judge, writ appeal was preferred, my lord. And in the writ appeal, a fresh order has been passed, my lord. So I think this contempt has become.
I do not have some instruction, Lordship.
Mr. Your name, please?
P. Sharma,
P.
Lordship.
Sharma, Learned Counsel for the petitioner. Also heard Mr. D. P. Bora, Learned Counsel appearing for the respondent, which submits that the order of the learned single judge was assailed in an appeal referred before the division bench wherein a fresh order has been passed. As such, this contempt case is not maintainable at this stage. Mr. Sharma, however, submits that he is not aware of the order passed by the division bench. In view of the above and on the request of Mr. Sharma, this matter stands adjourned for 4 weeks so as to enable him to obtain information.
Maybe one further thing, Lordship, if my learned friend is Lordship have the order. he may
Yes,
place-
my lord, I will.
Okay, 2 weeks, make it 2 weeks.
High level.
May
Yes.
please, your lordship. Non-compliance of the order date, my lord, 28/9/2015, man.
Yes, who is appearing? Yes, are you appearing in this case?
PWD. Not PWD.
PWD, man.
All right, then we'll direct personal appearance.
Man.
All right, heard Mr.
Yes, Upadhyay, my lord.
S.
Upadhyay.
Patel and counsel for the petitioner. Alleging willful disobedience of the order dated 28/9/2015 passed by this court in WBC number 4756 of 2015. This contempt case has been filed. None has appeared for the respondents, although the name of the learned counsel has been shown in the cause list. This contempt case was filed in the year 2019, and therefore it is surprising as to how the respondents have remained absent. Although the order of the court has still not been complied with. In view of the above, the respondent number 2, Sri Kamakhya Prasad Das, who is presently serving as superintendent engineer from a PWD Roads Division, Tejpur, is directed to appear personally before this court on the next date fixed. Registered to communicate the order of this court to the respondent number 2. This case again on 31st of May 2029.
I am highly obliged.
2023. Yes.
Item 38. Content.
Well, this is a contempt petition for non-compliance of the order dated 19/12/2018. I do not know whether the status of this, whether the order was complied with.
Lordship, here Mr. B. Gogoi appears, my lords, he's on legs, my lords, and as I've been told, my lords, 1 week's time may be given so that we can get an up-to-date instruction, my lords, regarding this, regarding area.
2019 matter, you.
Lordship, I just need to get an update, my lords, maybe. it
Mr.
has-
B. Chandra, counsel is present on the petition on the request of Mr. A. Chulia, learned counsel for the respondent. This matter is directed to posted again after 2 weeks so as to enable him one opportunity to obtain updated instruction and appraise this court as to whether any steps have been taken for compliance of the court's order.
Date may be given, my lord, in this case.
After 2 weeks. None appears to the petitioner on call, these matters concerned for 2 weeks.
Order has been complied with, he has got
Dr.
a relief.
Sharma, learned counsel for the petitioner submit that order of the court has been complied with, and therefore this matter be closed. Mr. S. Dr. Learned counsel is appeared for the respond number.
Respond number 2, my lord.
Contempt case stands closed.
Okay. I'll oblige.
I'm appealing for respondent number 1, my lord. Please.
Well, I bet for respondent number 3, my lord, we have filed our affidavit, my lord.
None has appeared for the petitioner. Mr. H. Chaudhary, learned counsel has appeared for respond number 3 and submit that he has filed his affidavit. Mr.
A. N. Sharma, my lord.
A. N. Sharma.
We also filed our affidavit, my lord.
Present on behalf of the respond number 1 and submit that affidavit on behalf of his client is also on record. After perusal of the affidavits, this court is of the opinion that this matter cannot proceed further without hearing the petitioner. Since the petitioner's counsel is absent today, this case will be listed again after 4 weeks.
My lord. Obliging.
Lordship,
Yes, Lordship.
Yes.
Lordship, here an area salary of rupees 35,344 needs to be paid, my lords. Here I am appearing for contender number 1. My lords, they had sent a proposal to the government, my lords, but I have the instruction, my lords, because of but it was not sanctioned by the government, because of which now again the government has given them the funds. So within 1 week, they'll send a fresh proposal for the petitioner's case, my lords. Can I just place the instruction, my lords?
Dr. G.J. Sharma, learned counsel for the petitioner is present. Mr. A. Chalia, learned counsel appearing for the respondent number 1 has obtained written instruction and placed the same written instruction dated 27/4/2023 and has placed the same before this court. Full stop. A perusal of the written instruction goes to show that earlier the proposal for release of salary of the petitioner was not approved by the government. Full stop. However, sanction for release of the salary has now been received during the year 2022-2023. Mr. Chalia submits that within a week from today, fresh proposal will be sent for payment, release
For
of
payment of
salary
the-
to
yes.
petitioner
1 month.
in compliance with the order of this court. Therefore, this matter be posted again after 3 weeks.
Yes, Lordship.
By retaining a copy of the written instruction dated 27/4/2023 with the record of this case, this matter is directed to be listed again after 4 weeks.
My lord, in this matter, we have received the instruction, my lord, we want to file affidavit, my lord. 2 weeks time may be granted, my lord. That's all.
Mr. M. Bhagavati, learned counsel is present on behalf of the petitioner. Mr. S. Datta, learned standing counsel, PNRD,
Yes, my lord.
Assam, appearing for the respondent numbers
1, 2, 5, and 6.
1, 2, 5, and 6 submit that he has received instruction in the matter and therefore 2 weeks time to file affidavit. Prayer allowed. Mr. A. Chakravarti, learned government advocate, Assam is present on behalf of
Respond number 3.
respondent number 3. On the request of Mr. Datta, this matter stands adjourned for 3 weeks
My lord.
so as to enable him to file affidavit. List accordingly.
Highly obliged, my lord.
None appears for the petitioner on call. This matter stands adjourned for 3 weeks. All right, there he is, wait. 47, listen, what is,
47, my lord.
yes,
Yes. My lord, this is regarding, my lord, non-compliance of the order passed by this honorable court. That order your lordship.
notice has not been issued.
My lord,
Will issue
not
notice.
issued, my lord. First
All right,
time.
Mr. M. Mandal, learned counsel for the petitioner alleging willful disobedience of the order dated 2/8/2022 passed by this court in WPC number 3776/2021. This case has been filed. I perused the averments made in the contempt petition. Stop. Issue notice returnable in 8 weeks. Petitioner to take steps for service of notice in the response by registered.
Can it be, my lord, 4 weeks, my lord? Regarding, my lord, pensionary benefits.
6 weeks.
Develop, please.
I don't know why it has come for orders. Generally, it is a contempt. It should come for a motion.
That's right, but nowadays these things are.
The only
Will
difficulty.
issue notice,
Yes, notice will go only.
which
but-
is which order has not been complied.
Yes, my lord, the order at page 12, operative portion is at page
And
18.
Mr. D. Das, senior counsel, assisted by Mr. K. Mohammed, learned counsel for the petitioner. Alleging willful disobedience of the order dated 7/4/2022 passed by this court in WPC number 4475 of 2020. This contempt case has been filed. I've said everything same 6 weeks, yes. The last matter.
May it please lordship. It is a substitution petition, lordship. The petitioner died and he has 2 sons. So that
Who has died? Who died?
first time. Please, your Honor.
The writ petitioner.
Yes, lordship. So in this case, lordship, the claim is of gratuity, lordship, gratuity amount. Therefore, that is to
Notice, notice. has to be issued.
No, notice to whom?
Notice to 1 and 2 lordship, the company.
No,
I am
that-
appearing for 3 only.
This IA has been filed with a prayer to substitute the original writ petitioner who has expired during the pendency of the writ petition. First of Mr. S.S. Roy, learned counsel appearing for the respondent number, learned government advocate Assam appearing for the respondent number 3 submits that notice must go to respondent numbers 1 and 2 before the prayer can be considered. First up, in view of the above, issue notice returnable in 4 weeks. Upon the respondent numbers 1 and 2, steps were registered post to AD.
Yes, lordship. Obliged.
Anything, any